In response to the institutional failings highlighted in the Betrayal of Trust inquiry, the government added a new offence to the Crimes Act that places important new obligations on people who work with children. From 1st of July 2015, it is a criminal offence to negligently fail to protect a child from sexual abuse perpetrated by someone associated with your organisation. The failure to protect offence is in section 49C of the Crimes Act Victoria, and it says that a person will commit an offence if 1. They hold a position of authority within an organisation that works with children. 2. They know of a substantial risk that another adult associated with their organisation will commit a sex offence against a child who is under 16 within the organisation's care. And 3. They have the power or responsibility to remove or reduce that risk, but they negligently fail to do so.
This law applies to organisations that exercise care, supervision or authority over children, whether that's part of their primary functions or otherwise. This means that it's going to apply to organisations like churches and religious bodies, schools, children's services, out-of-home care services, hospitals, government departments, sporting groups, youth organisations and charities.
So the new law doesn't actually specify what a substantial risk is. So you may be confused and say, well, is this risk substantial or is it not? Unfortunately, there's been no assistance at this point to explain what a substantial risk is. We do have a little bit of guidance, and that guidance says that you don't have to have a sexual offense that's already been committed for there to be a substantial risk. So that means that sometimes there might be a situation where an offense is yet to be committed or might be committed and there still is a substantial risk to children. So we're talking about also people that are associated with your organization. That includes owners or directors of the organization, managers or team leaders, or any other employee. It also includes, interestingly, people who are coming in and out of your organization. So that might be contractors that come in and out, volunteers or students on a placement, temporary staff members, locums, casual employees, or if you're in a high traffic area and you know people are coming in and out regularly to do maintenance works or safety works, you're responsible for all of those people because they're associated with your organization.
But doesn't this law only apply to people who hold positions of authority? Yes, but it will apply to workers who are not necessarily in management roles. If you have the power or ability to reduce a risk to a child, then this law will apply to you. A person will contravene the failure to protect laws if they negligently fail to reduce or remove a risk to a child. Negligence involves a great falling short of the standard of care that a reasonable person would exercise in the circumstances.
So, what does the law say I should do? You won't be prosecuted if you took reasonable steps to protect a child from the risk of abuse. For example, where an allegation is reported and the person concerned is removed from any child-related role pending an investigation.
Let's look at an example. Imagine you run a holiday program for young people under 16. You want to arrange for a local football team to come in and run an activity with the group. A colleague of yours tells you that there was a problem with the same football team when they came and worked with your organisation a few years earlier. Your colleague tells you that there were rumours that a player gave his number to one of the young people and some inappropriate texts were exchanged. The child's parents contacted the organisation and were very upset. Your colleague thinks the police were involved but can't remember exactly what happened. Would running this activity in your holiday program pose a substantial risk to children? Possibly. You are engaging an adult football team to come in and work with children under the care of your organisation. It sounds like previously there may have been some issues with the same club which were reported to police. Do you have the authority to remove or reduce any risk to the children? Yes. You are running the holiday program, so there are things you can do to keep the children safe. For example, if you decide to run the activity, you might Use a different football club or code if you are not satisfied with the club's approach to working with children. Run training or an induction for the players so they know what is expected of them. Ask the visiting club to provide working with children checks, and ensure adequate supervision of children during the activity. If you take these types of reasonable measures, you will be keeping children safe and you will not fall short of the new failure to protect law.
Although the new failure to protect law is concerned about what you do when you're at work, it applies to you as an individual and it takes precedence over your organisational policies and procedures. If you act negligently, you can be held criminally liable.